changing lives.
Appreciate that. Now, what they're doing here is Paul is coming down. I believe he's with Barnabas on this trip, or Silas rather, and they're talking to the leaders in Jerusalem, saying we've had some challenges with the Gentiles.
We'll try to be punctual today. We're a bit late. Forgive us again. Why? Forgive us. So last 2 weeks we discussed a little bit about when to start a business, how to start a business. And my take home personally was the fact that, you know, all things being equal, you may want to start a business, but someone else will also want to start a business. And if someone wants to start a business, has anyone ever in your lifetime asked you to partner him or her in a business? That is the currency you have now. If no one has ever done that, that means you have to start looking around. Maybe you have to start changing things. Maybe you are not that trustworthy. Because it can't always be that you will start the business. It's possible someone else will start the business and invite you in. So have you put yourself in a position where you will be invited in? That's how it's going now. So today we are going to discuss another interesting topic. So we've already discussed how you can start your business, right? All the legal documents that you have to start with. You know, going to the office of the Registrar General of Registrar of Companies to register your company, the type of company you have to. If you've not watched it, please go to Facebook, the Law Chamber. You can go and watch all that there. We've also discussed about when to start a business. You have to be 18 years and above to be able to start a business, and all those things. So today, you're going to discuss some of the legal documents that you need to start a business with. Legal document that you need. So let's say, for example, agreements. Which agreement do you need to have in place? If there's a problem with those agreements, how do you resolve it? Do you always rush to court? Are there other options? That's what we're going to discuss today. So sit back and enjoy yourself. And please, you know this program is live. So if you have any questions at all, you can send it to 0559 680066. 0559 680066. So share this, go to our Facebook page, the Law Chamber, share it wide, and ask that friend who is interested in starting a business. Ask that colleague who is interested in a business to join us. So let's go for this short commercial break. When we come back, I'll introduce my guests to you, and then we'll dive in proper. Again, I am Anita Delight. Let's go for this short commercial break.
As a small business owner, Mitaisha Business Forum, our Hope channel, it really helps me with my business.
Don't let your priorities be because obi eye bibinti. Also share some wide. Why one kasa sawasa. So jani ni obi ani.
Okay.
Obi ani need so that ungo fa a problem ma was.
In the first place, business a risk.
Okay.
It's just all about risk. Now person your business, so now you need you should be a risk taker.
Okay.
I would recommend it to you to mess resa also beshebi.
Today we think that Christianity is just some sort of a jacket we put on and we get home and then we take it off and all of that.
If Israel had felt so comfortable in Egypt, would God have gone to deliver them?
God will not come to redeem a people who have themselves adjusted their lives so much to this world.
Without oppression, without tribulation, without trials, there's no need for deliverance.
In this new series of our Bible-based conversations, we are looking at the examples and the experiences of the children of Israel in their journey from Egypt to Canaan, and how this mirrors or parallels our Christian journey, even as we await the second coming of Jesus Christ.
The journey Egypt to Canaan experience and its essence to us today. Showing this and every Saturday at 6 p.m. only on Hope Channel Ghana.
Welcome. So the topic again is what? Doing business in Ghana, shareholders agreements, commercial contracts, and dispute resolution. I'm supposed to have 3 guests today. Unfortunately, I have 2. One of my guests had an emergency today, and frankly speaking, there's nothing she could have done about it. And so I want just to tell him about all the best here. God be with you. So I have 2 gentlemen here, which I usually will not do because I want gender balance. But today I'll take it like that. So I have 2 gentlemen here to help me. So my first gentleman is lawyer Adai Boateng Ichampo. If you're a lecturer or you are a student at Valley View, you already know him because he's a lecturer with Valley View University. He is a lawyer, yes. And at Valley View, he lectures business law, company law, legal environment of business, and industrial law. Valley View for a babe, which is president, 4 areas of law for 1 person. All right.
Answer.
How are you doing it?
We manage it.
4.
Yeah, it's like giving to my alma mater, you know.
Oh, Charlie. You're from Valley View?
Yeah, I did my first degree at Valley View before I started in my LLB and the LLM.
Oh, okay.
Yeah, so giving back to my alma mater.
Oh, Charlie.
That's how we are going to do
4.
it. Yeah, we will get there. We will get there.
What did I do, back? Why?
We can swap.
No, not swap. You're welcome. You're so welcome.
Thank
and you
you
also work with Cocoa Board.
Yeah, I'm actually with Cocoa Marketing Company. That's a subsidiary of Ghana Cocoa Board. We have subsidiaries and divisions in Cocoa Board. Yeah, I'm the senior administrative officer with the legal department.
Hey, who this guy?
Oh, no, cancel. Oh, no, not much.
And yeah, that's a good combination.
Yes.
So I think the single ladies should look out for you. And there's someone there.
Oh, let's see what God will do.
Hey, the single ladies. You understand? My second gentleman is also a lawyer. Actually, he's a colleague of mine. We're all in the same law firm, Atiguben Associates. And he goes by the name Lawyer Courage as a Bagna. He's also a lecturer. And then the lecturers, also. But my mom my technical. He's called Lawyer Courage as a Bagna. He's a lecturer with University of Ghana Law Faculty, University of Ghana, Honam. He lectures in corporate business transactions and law of corporate finance. Hey, he's also a legal associate with BNP Associate. I realize that most lecturers, Courage, welcome.
Thank you.
I realize most lecturers also practice. Is it very important to practice as a lecturer?
Yes, but just to correct you, I'm no more with BNP. So
okay.
Yes.
So are you now?
I'm with Lex Vanef. Lex Vanef and Associates. Vitus Ba is our managing partner.
Oh, Vitus!
Exactly. So.
Oh, I didn't know that.
So
Vitus is another colleague of ours.
Yes.
Oh, that's beautiful.
Kaka.
And what's your portfolio there?
Senior associate too.
Oh, Charlie. Charlie. Wild there. Says can be. Vitus the Scabell.
Oh, yeah, sure.
You know when you talk about body, everybody tells a bladder. We have because of Oscar. All right, so let's delve in. When you start a company, Courage, what are some of the agreements that we have to look out for, that it has to be in place to have an effective company?
Okay. Thank you very much. I think this question is one that is very expansive, that will be very difficult for us to exhaust everything here. But I'll try to keep it on a very simple way so that our audience can simply get the needed information that they require. One thing I'll say is that before you start a company, or let me say, a company is you going into business, right? So in every business that you do, I always say there are three important things. There are three important things that feed into whatever business that you go into: value, return, risk. So the value is what you put in. The return is your expectation. The risk is how do you manage your risk. With this in mind, in everything that you do, you must have these three things in mind. How do I make sure that I get my value back in terms of my return, and I mitigate my returns or my risk? So if you start a company, essentially there may be several contracts that you may go into, but there are 4 key strategic contracts or contractual agreements that one will sign. One, there's always that shareholders agreement between the concerned parties, those going into the business. So shareholders agreement, which we'll come into later, and then you have your management service agreement, where you outsource independent bodies or persons to provide services. So for instance, I'm running a business. I may not have all the resources, but I need a third party to provide some services to my client. That person is not my employee. That person is an independent contractor. So that is a purely service management agreement.
Give us an example.
So I decide to provide IT services to secondary schools. I set up the company and all that. But maybe the installation and other things, I may not have the expertise in it. There's already a company that is into that. So instead of me investing in that, I'll outsource it to that company to provide the services to my customers. So that is a service management agreement that I have to sign with them. And that one, you have to look at what is the scope of the service. Because the scope of service feeds into the next thing, the fees you have to pay. Then the next thing is the terms of payment. Then how do you limit your liability and default? So there are several things that you have to look at. So
we'll look into the details of the...
Exactly.
So we have 2 now.
We have 2. Then the next thing you have to look at is your employment contract. Okay. Which those are the people that you employ to work with you, which is very, very important. There are several things that you have to look at. Then the last thing is your confidentiality agreement. Your confidentiality agreement cuts across your employees to third parties, to customers, to service providers, and all that. And it's important that you look at all this. So if you look at these 4 agreements that I have said, you see that a distribution contract falls into one of them. A sale representative agreement falls into one of them. A bonus agreement falls into one of them. So these are the 4 main contracts or agreements that every person who wants to start a business must keep in mind.
Okay, so let me try and understand. So we have 4 agreements. If you start a company, you need to have in mind that there are 4 different types of agreements you have to enter into. So the first one is between the owners, the shareholders. Yes. The second one is between you and independent people. Maybe you need your office cleaned, so you contract a cleaning services company to come and clean your office for you. There have to be agreements for such groups as well.
Yeah.
Then the third one is your employees, the people you work with. You have to have an agreement with them. So it means that, and the last one is confidentiality, so that none of these three people or any group you work with will spill the beans, in quotes.
Exactly.
So these 4 agreements, every company should have it. Is it a must? Is it a must, Hadai?
All right, Council. Well, since we are talking about businesses in Ghana, let me also avert our minds to other types of businesses. You see, most people think every business is a company, but we have other types of businesses as well. We can make mention of the sole proprietorship, the
partnership. Do you remember those ones? Last 3 weeks, that's the first you remember? All right.
Yes, sole proprietorship, the partnership. Council has said much about the company. Let me avert our minds to the sole proprietorship, the partnership. Sole proprietorship basically has its own laws. That's Act 151, Registration of Business Names Act. And that is one man's business. You starting up your own business. And per the Act, it's not necessary to register the sole proprietorship business if you used your real name. Let's say Mere Champon Enterprise or Mere Champon Ventures. If you use your real name to do this kind of business, the Act says it's not necessary for you to register this business. But for purposes of securing contracts, it would be advisable to register and get a certificate down so that you can use this name to register your business and secure your contracts. With sole proprietorship, it has advantages and disadvantages as well. You are managing the business, so you do virtually everything. You are the marketing officer, the procurement, accounts. So making decisions with sole proprietorship is very simple because you need not consult anybody. You take every decision on your own. And with that one too, you don't pay corporate taxes. That has to do with the income tax. And when it comes to the liability, you are not separate and distinct from the business. You are one. So even the event of the business collapsing, there is the likelihood that you also lose everything when it comes to that.
The business.
Yes. For example, you are selling wachi, and unfortunately you kick the bucket. If you don't have anyone to help you continue with this kind of business, the wachi business is also going to collapse. Definitely. So it is one disadvantage when it comes to the sole proprietorship type of business. And the other type of business has to do with partnership, which is being governed by Act 152. With partnership, we can come together, the two of us, Anita and myself can come together, and other people. But the number shouldn't exceed 20. And that purpose is to make profit. That is the bone of contention here. If we come together that we are going to do business and we are not going to make profit, we cannot classify this as partnership. So it is forbidden for us to have this kind of partnership if we have 21 partners doing this kind of business. So basically, these are the other types of businesses as well, so that we don't always say every business is a company. Mere Champo Enterprise cannot be classified as a company. Anita and Associates cannot be classified as a company. That has to do with partnership, and the other one with sole proprietorship.
So are we then saying that if it's any of these type of businesses and it's not a company, you don't need agreement? Because that watcher seller or that Anita company, enterprise, and those partnerships, don't they need agreement as well?
With sole proprietorship, it's not necessary for you to get the agreement. The agreement is essential when it comes to partnership. For partnership, you must get the partnership agreement, which needs to be filed.
You need a partnership agreement.
Yes, you need, which will be filed with the registrar of companies. So you have to get the names of the partners, their address, the location of the business, you state their occupation. Most vital details will be taken to prepare this kind of partnership agreement. And this is to prevent future disputes, of which I think we will get there later.
Get there. So, but let's be, it's not mandatory. But is it advisable? Because you are a company, Anita and other company partners, but we are going to employ people. Shouldn't we have an agreement for such people, the employment contract? We are going to employ third parties to come and work with us. We are going to have confidential information. So are we then saying that it's not mandatory? Yes, but is it not advisable for them?
Yes, for partnership, it's advisable for us to get the agreement. You see, when we employ people to work with us, as we said, Anita and Boatin and Associates, we need those people to work with us. They must get their employment contract. we have to state what they are supposed to do in the partnership, what they are not supposed to do. We communicate clearly to them what they are supposed to take at the end of each month. So this will guide them in discharging their duties as employees of Ade and Anita and associates. So these agreements are there to serve as a guide for all of us to know what we are supposed to do and what we shouldn't do going forward.
Please, are you taking the tidbits here? Very, very important. So, Courage, let me come back. Let's delve a little bit into it. When we talk about the shareholders agreement, you've explained that it's the owners coming together for the agreement. So in this agreement, can you just give us a little bit of what's supposed to be in there? Then for the four, like, sure.
Okay, so just to touch briefly on, before I answer, before I move on to your question. Now, when it comes to the sole proprietorship or whatever business it is, the scope of activity determines whether ordinarily it is advisable or otherwise to go into that business. So like he said, sole proprietorship, I don't need a shareholders agreement. It's my own business. So you see that the agreement between the owners is not necessary. But if I'm operating a wache, a joint business, like a wache business, and I have different branches scattered, and I have people supplying me meat, this and that, then a supplier's agreement becomes important because that's a third party you are dealing with. So that's a service management agreement. So it becomes prudent that you do that because you never know when you run into issues. Now, to your question on the issue of shareholders agreement. Now, there's this issue as to a shareholders agreement and a company's constitution. I'm just adding that to give our viewers some clarity on the issues. Some say, look, once you have a company's constitution, there's no need to have a shareholders agreement. There's always some overlap. But the shareholders agreement it governs the relationship between the owners of the business. And a company's constitution governs the relationship between the company, the owners, and all other relevant stakeholders, which is very broad. So sometimes you may have instances whereby a shareholders agreement is provided in a company's constitution. Others may decide to make it separate because of commercial convenience or whatever. Now, to your question, a typical shareholders agreement is very broad, depending on the scope of activity and all that. But there are some main things that a shareholders agreement must contain. Mm-hmm. One, the proportion of ownership or share. Okay. So what do I mean by that? You and Anita and my very good friend here, we enter into a business. The question is, what is the proportion of ownership or share?
60-20-20.
60-20-20.
Oh, yeah.
That is 100%. Mm-hmm. You get it? So it's important.
And you don't agree. Don't do that.
I
agree.
Yeah, we agree.
Yes.
We don't want.
Yes. Take the system.
It's okay.
Take the system.
So that is one thing that the agreement must provide, because that goes into a whole lot of issues. The proportion of shareholding determines a lot of things in terms of your rights, so far as voting is concerned, so far as appointment is concerned, and a lot of things. So since you have 60 and you are the majority shareholder, it's very possible that when it comes to voting, your right to vote in terms of your number is more than us. Right? Then the second thing you have to look at is your dividend policy. When I say your dividend policy, how do we want to distribute, let me use the word profits made after tax? Because it is not always that we want to distribute the profits. It's possible that we may have a policy that we should have what we call retained profits. Let's plow back the profits into the business and all that. So we have to decide on that. Then the next thing we have to do is what we call the exit framework. How do we exit? Can you just stand up at any point in time and exit? So if you are going into business,
exit and leave the business.
Yes, leave the business. So if you are going into any shareholders agreement, how do you leave the business? Can I transfer my shares at any point in time? So there are instances whereby there may be restrictions. There are several levels of restrictions which time will not allow us. We have what you call the drag or the tag and a whole lot. The drag is if I'm the majority shareholder and I'm buying shares, I can drag a minority shareholder with me. Then the tag is where the minority can tag with someone, so which time will not allow it. So there are restrictions where you can't just go and sell your shares to another person without going through the procedure, preemptory rights and all that. So you have to agree on all those issues. Then we have what you call reserved rights or reserved obligations. And what do we mean by that? There are certain decisions that you feel that they should be left for the shareholders to determine.
Okay.
Something like we want to vary the shares. And what do I mean by that? So you have 60 for 2020. A time will come they want to reduce yours to 50.
You mean increase?
Okay, let's take it. Increase it to 70. Can the directors just do that? They have to come back to the shareholders to determine that. We want to reduce the stated capital. How do we? So you have to look at all those issues.
So that's for shareholders. So there's a whole complicated
yes,
one.
Yes, it's
so
a whole...
what about the second one?
The second one, the employer's contract, which essentially has to do with the scope of the person's work. It's very important. You have to determine that. And the person's leave rights, the person's enumeration and all that, the person's right, what the person is entitled to and all that, has to be clearly stated. So you define it in a way that the person is abreast with the company's policies and guidelines and all that. And especially it takes a different twist when you are working with an international organization. So established in Ghana, we are working with an international organization, you are providing service to an international organization. Then your employment contract may not necessarily be the same like somebody who is operating within, because there are certain compliance issues that you have to pay attention to. Then the confidentiality agreement. What can be disclosed, what cannot be disclosed, who can disclose it, who cannot disclose it, within what period or within what time must you regard that as not what? Confidential and all that, which is very important and all that. Trade restraint contracts. I'm having a hairdressing salon. I've employed you, Anita. You are the main person. You know all the customers. Can I restrain you? Now, when you leave my business, the next 2 years, you can't engage in any hairdressing business. Is it possible to do that? So those are things that you have to consider.
And then the external one?
Then the service management agreement. Again, that one, you are looking, like I mentioned, what is the scope of service? You have to agree on that. Then the fees that you have to pay. Then the issues of third-party liability. The person you've engaged as an independent contractor, the person may go and cause harm or damage to a third party in the course of providing business for you or carrying out your obligation. To what extent can you be liable for such things? So you have to look at all those issues to ensure that, like I said, your risk is being managed or minimized or mitigated, you have value, and there's return.
With this, I'm coming to the realization that you will necessarily need a lawyer, or can I do it on my own?
Well, we have Companies Act 2019, Act 992. This regulates every company in this country. And per Section 7 of Act 992, we have different types of companies. We have companies limited by shares, companies limited by guarantee. We have unlimited company, and then external companies. With companies limited by guarantee, they do not need shareholders agreements. So if you do not have the idea and you don't involve the services of a legal practitioner, you don't involve the services of a lawyer, you wouldn't know that, for instance, you have established a company limited by guarantee. Company limited by guarantee is a not-for-profit making organization. Therefore, you don't need shares. So once there are no shares, there is no need for you to even get shareholders agreement. But for the others, whereby you require shares, like for instance, the company limited by shares, you have to need the services of a lawyer to guide you so that the lawyer can draft the agreement for you. If you do not know anything about company law, lawyers are there. They have the requisite knowledge when it comes to company law. So lawyers will definitely be there to guide you, to assist you to establish your agreements, which will involve you going forward with the services and everything that you do in the company as well. So for companies limited by guarantee, like the NGOs, they are meant for charity, educational purposes. Other companies limited by guarantee, like the churches, religious purposes, they are not making profit. They are not supposed to make profit.
The churches are not supposed to make profit.
Yes, but we know what is going on there. Yes, these companies are not supposed to make profits. When you are found making profit, the law can deal with you. So companies limited by shares, they need the shareholders agreement. So we should have it at the back of your mind. It is worthy of note that the shareholders agreement that council have been discussing so far is meant for companies that have shares. The shareholders will be guided by this agreement going forward.
So if I need any of these agreements, when should I start drafting it? Is it when the company is set up? Is it before the company is set up?
You see, upon incorporation, the company becomes...
What does that mean? Like, I want us to calm very down.
Okay, when you register your company, okay, the law has specific guidelines. You need to get at least 2 directors in the company per section 170 of Act 992. You must get a company secretary, auditor. If you don't have an auditor, the registrar general will even appoint one for you. You have to get all these in place. Once the company kickstarts and you have shareholders, I think it is prudent for you to get the shareholders right from the beginning, because disputes are meant to happen. And when there are no agreements to guide us, though we have company constitution, of which council rightly mentioned, the company constitution is regulating the affairs of the company. The shareholders agreement will guide the shareholders in the company to avoid any future dispute, especially when it comes to dividends. Dividends are the profits when the company makes and decides to share the dividends among the shareholders. So right from the inception, from the registration of the company, it's advisable for us to prepare the shareholders agreement with the assistance of a legal practitioner.
That's interesting. Okay, so now let me come to disagreement. So the idea is that, okay, so the company is you've incorporated a company, you have all these agreements, and of course within the agreement there will be a form of dispute resolution. My question is, when there's a dispute, do we always have to run to the court? If not, are there other options? And what are they?
All right. We mostly know of going to court whenever a dispute ensues between parties. But we have to also know that we have other forms of dispute resolutions. In Ghana here, we have the Alternative Dispute Resolution Act 2010. This was assented on 31st May 2010. With this arbitration, mediation, negotiation, conciliation, our Act makes mention of arbitration and mediation. The Act is silent on negotiation. Negotiation is when a dispute ensues between parties and the 2 parties decide to negotiate and come to terms and see the possible way they can come out of the dispute. When I have a dispute with Courage, the 2 of us will then meet, we find a convenient place, we discuss issues. With a negotiation, you don't need a third party to help you resolve the disputes. But for mediation, you need a third party who is a neutral person to the dispute. This third party is known as the mediator. The mediator will meet you, discuss issues with you. Both parties will tell their side of the stories to the mediator. Again, the mediator can also have a private discussion, which is known as the caucus. If we are in the dispute resolution settlement between myself and then Courage, and Anita is the mediator. When Anita decides to have the private discussion, that's the caucus, Courage would excuse the 2 of us. You have that discussion with me. I will excuse you. You have another discussion with Courage. With mediation, the mediator does not necessarily come to the terms that the mediator is rather bringing the dispute solution. No. The mediator is rather helping the disputants to arrive at the possible best solution to resolve the dispute. So the two of us will then put things on the table. How best can we help each other? And then you, the mediator, will facilitate and assist us to come to the right conclusion to solve this dispute. Arbitration has been mentioned in the Act. It's elaborative, it's efficient, and with arbitration too, is the most formal way to resolve disputes. With arbitration too, you need a third party who will assist the both parties to come to the conclusion of the matter. The third party is known as the arbitrator. We need to have someone who is skilled, who is an expert in the field. Let's say an architecture, a lawyer, someone with a financial background, a banking background, who can help us to solve that dispute. So the arbitrator will meet the two of us. Mostly, the disputants or the parties will decide the seat, the venue, how they will choose the arbitrator. If we know that the dispute that we are having is technical, we need to get an expert to help us resolve that issue. So this arbitrator will meet both parties and try to come out with the best possible solutions. With arbitration, it isn't the same as mediation, whereby the parties bring their own solutions. The arbitrator will then give the solution, which is known as the award. Like going to courts, the judge will now give the judgment. Arbitration
so that becomes final.
Yes, but you can even challenge.
In court.
You can even challenge arbitration. If you are not satisfied with the award, you can challenge it at the High Court, because even the Constitution, the 1992 Constitution, makes mention in Article 30 that all issues regarding human rights must be taken to the High Court. So arbitration matters when the award is being given. You can challenge the award if you are not satisfied with it. Maybe the arbitrator was biased. You've realized that the arbitrator wasn't competent in trying to resolve the dispute. You can challenge this issue at the High Court. The High Court will then try and then bring the solution as well, so that both parties can have peace. You see, one advantage about ADR, or alternative dispute resolution, is that it preserves relationships. When you go to court, it's a win-lose thing that you are going to have. If you most of the times, the winner wouldn't be satisfied with the judgment when it comes to litigation or going to court. Arbitration, we can preserve the dispute and the relationship as well. Because if courage is a relative or a family member, and we are at the arbitration session, once the dispute has come to an end, you will see that yes, we are fulfilled with the award, though there will be challenges here and there, of which one would decide to go to the High Court to challenge the award. But at the end of the day, the motive of the arbitrator is to preserve the relationship the two of us are having. Again, it is fast as compared to litigation. It can take a week or a month for the arbitrator to resolve the dispute between the two parties who are at the arbitration session. Again, it is not expensive. With litigation, you have to pay for court fees, you pay lawyers here and there. Some lawyers even try and take the advantage to extort money from their clients.
We take an exception. We take an exception.
Well,
that was just
yes. You see, with arbitration, you don't involve a lot of money. It is less costly as compared to litigation, and it is fast. You get the dispute, the solution, the award within the shortest possible time. At the end of the day, everyone will be satisfied with the award that has been given, despite the fact that I've made mention that you can petition or you can challenge this at the High Court.
Okay, that's a lot to take in, isn't it? All right, so let me try and start from the top quickly so that we can summarize this up. So generally, you've gone to the Office of the Registrar of Companies, you've registered your company, you've started your business. But before then, you ask yourself, which type of business am I doing? Am I going to sole proprietorship, partnership? Is it a limited company? If it's a company limited, is it limited by guarantee, shares, all that? So you now know the company you are going to go into. Now you've gone into it, and now you've started the business. So before you start the business, the question is, what are some of the agreements that have to be put in place? Some people start their businesses and there's no agreement whatsoever. You ask someone, I work here, where is your employment contract? I don't have any. My employer didn't give me any contract. This particular topic, employer-employee relationship, will be in season 4. So next season we'll tackle this particular topic. But the person doesn't have. You have contractors coming to work in your company. There's no agreement whatsoever. There's an issue and you're all over the place. You're going to court. Sometimes there's no need to go to court, because if you have the agreement, within the agreement, in it you can say that you resolve the matter amicably or go to ADL. As we said, ADL, it's like the court. If it is arbitration, when the arbitrator says this, it goes, and you can even ensure that it is the court upholds it for you and then enforce it for you. So let's look at all these dynamics. And so, Carrie, this leads me back to you, that when someone starts a business, what they're thinking about is, I've started a business, I'm employing people, I want money. They are not thinking of all these other agreements that have to be put in place. They're not thinking of how am I going to resolve issues that come up with it. What is your advice and what's your take home when it comes to such persons?
Okay, thank you. Yes, just to take it from where he picked it from in relation to your question. Now, I always tell people that as a business person, I know getting a lawyer is very expensive in Ghana here, but I always advise people that engage a lawyer from the beginning, in the sense that if you are negotiating businesses or you are trying to establish a business, there are certain things that a lawyer will pay attention to that you will not. So for instance, the dispute resolution that he rightly mentioned. Now you see that depending on the agreement and what the people agreed on, will always bring the question of alternative dispute resolution. So you have instances whereby it's on contractual basis, where it is not contractual basis, and where it's statutory. Now what do I mean by? So you and Anita and I, as shareholders or as whatever, we have agreed that if there is a dispute, we'll resort to ADL. Non-contractual is where we have not agreed, but there is a dispute and we then agree out of the dispute. The statutory is whereby there's a statute, a law, that says that we must first resort to what? Dispute resolution and all that. So when you are negotiating the agreement, then you have a lawyer. The lawyer has that in mind. You get it? You, the business person, may not have that in mind. So my take home to a lot of people is that, look, depending on the type of business, no matter what business you are doing, it's always important that you engage a legal person to at least give you a legal perspective as to what you are doing. Because the end result is always important for you, the business person. It's the agreements and all that. There are instances whereby I have had people who go online, get a draft agreement
yes.
on their own.
Yeah.
I recently I was helping somebody in a business setup, and after a year, he felt perhaps maybe I'm charging too much. So he went online, did his own thing, went to sign a 70 million Ghana cedis agreement. And now he's not been paid a cedi. There are issues. He has come back.
He always come back.
He sent the agreement to me to review. I told him that, how can you, a lawyer, draft an agreement for me to review? You are essentially telling me to draft a new one. You see, but when I looked at what the dispute is, I was like, if he had gone in with a lawyer, there are certain things that would have taken care of. You see, because you are going with a different mind framework, with a different thinking, whilst the lawyer also has a different absolute thinking. So my advice is, look, regardless, no matter what, always make sure that, look, you reach out to that legal person, no matter what, there's something in for you, especially when you're dealing with third parties, whether your employees, your suppliers, your distributors, or whatever, because there's always a point that you have to resort to what you agreed. And people are like, what about if we start and I've paid money to you, and you turn around and say, look, I'm no more interested? what happens to the money? Oh, pay back to me. Look, then it becomes a whole lot. But as a lawyer, if I'm drafting the agreement, I know how to take care of payment terms. If I pay money and this happens, what is the result, or what should be the resultant expectation? You, the business person, you might not agree on that. So my advice is, look, times are hard, but always try and seek the advice of a lawyer.
Because it's often even more expensive. When you don't get the lawyer, you're in trouble.
If you're in trouble, it's about 20 times. It's very, very expensive. And sorry to say this, with all apologies, it looks more like the foreigners, when they come to Ghana, they always want a lawyer to start doing business. Like, if they're going to do a business, they need a lawyer. That has been my observation, with all apologies, not to say that Ghanaians don't. But
that's the truth.
Yeah, but there are some few Ghanaians that, look, they go and when everything is gone wrong, then they come to you.
There was one friend of mine, she also did the same thing. She went online, went to do all that thing, and when she was done, she sent it to me to review. And I'm like, so you sit there, you draft your agreement, and you send it to me to review, so that you will not pay, or so that you will pay less. That's
you
how
pay
it
the
works.
review, pay
because the way you bring that agreement and I'm reviewing,
essentially
I'll be charging you as if you've not done anything. So why did they have that? All right, so now let's, Augustina Echampo is watching us live from here. Augustina, we can see you. Cheba for MacP. It says, very educative program. Big ups to my senior Vandal doing justice to the subject matter. Courage Asabagna. You're a Vandal?
Yes. Proud.
Ata Kwachiwa says, keep up the good work, Anne. Thank you. Nana Kofini Mako. Hey, my pastor. Great discussion, guys. He says, good evening to you all. Kind regards to Lawyer Boati Echampo. From pastor himself. Philomena Becca is watching us. Philomena says very educative. All right, so do you still have your take-home point? Have you gotten it yet? You haven't. You should, though. We're about running up. So, Counsel, what's your take-home for us?
Counsel Courage has mentioned a lot. You always need the services of a lawyer. Don't overburden lawyers whenever you crash. You see, before you enter into contract, there are certain things that you need to know. You must know that there is an offer, acceptance, consideration, intention to create legal relationship, capacity. You see, all these must be present, but you wouldn't know because you do not have any idea about all these things. So the contract that you have entered into, is the contract valid? Is the contract invalid? How will you know? Because you cannot go and download a contract and then crash and later on bring it to Courage to do everything afresh for you. You are overburdening him. He has already got lots of things to do. So always secure the services of a lawyer. Let the lawyer guide you so that you get the right things to be done in order for you to avoid a whole lot of stuff. Because with agreements too, there can be even force majeure. That is incidences of natural disasters, natural calamity, unforeseen circumstances. When that happens, what will you do? If you have no idea about all these things, the lawyers are there to guide you. You see, when there is a force majeure, for instance, in the case of Taylor and Caldwell, whereby they hired a hall for 4 days to perform, and then there was fire outbreak in this case. So assuming we do not have any idea about this, there is no lawyer, and we have entered into a contract, we've secured the hall, we've paid for the hall, and there is fire outbreak in the hall. What are we going to do next? Are we going to take our money from the hall people, or we, the people who secured the hall, we are going to pay monies? Because if there is a lawyer who will guide you, you have to know all these things, then you solve these issues amicably in order for you to avoid a whole lot of unnecessary litigations. So the services of a lawyer is very important when it comes to starting businesses.
I know by now you are saying that we are promoting our own work, right? Yeah, promoting, but we can't say it enough, because most times someone comes to you and you look at the case and you realize that we could have easily ensure that this matter didn't come up if you had gotten yourself a lawyer in the first place. So that's very, very important. So Courage, let me take your final word. we've spoken about the kind of contracts you need when you start a business, how the type of resolutions you have to go into, not necessarily going to court, always running to court as a first point of no. You don't need to do that. You can have in a contract ADR so that resolve it amicably, or a third party come and help you resolve it. So, Courage, give me your final words. What will be your final words to Adia?
Yes, so my final word is very simple. One, if you're going into a business or you're starting up a business, there are so many people you deal with. But as a business person, always keep these three things in mind: value, return, risk. And you have this in mind, or if you keep this in mind, you will know how to be guided. 2, engage an expert. So if I'm going into a business that I don't have the expertise and it involves a lawyer, I engage a lawyer. If I'm going to something that requires an economist, a financial investment person, I engage that expert. Because again, you want to ensure that there's return for your value and you mitigate your risk. So that is all that I have for our viewers.
Yes, also.
All right. What I want to say is that if you want to start a business, there is no need for you to force yourself to register a company. You can start with sole proprietorship, manage it, know what to do, whatever that you are going to do. You learn from the sole proprietorship because it is assumed to be the smallest before you grow to establish the company. So don't put it at the back of your mind that every business is a company. Start with the sole proprietorship, name it. Anita Enterprise, Georgia Champon Ventures. Start from there and get to learn before you go into the company. Because with the company, you will need at least 2 directors. You must get a secretary. Of course, the secretary should be a lawyer. You must have an auditor. You will be paying corporate taxes here and there. So if you don't start from the smallest, when you get to the biggest one, it's going to be tedious for you to manage a whole lot of staff in the company. So my advice to viewers is that let's start small. Let's try to learn, engage the services of lawyers to help us establish our businesses, for our businesses to grow, because we are establishing these businesses to make profit, to make ends meet. No one would like to establish a business and operate at a loss. So viewers, always try to engage the services of lawyers to have a fruitful business.
Thank you so much, Counsel. Thank you. And so one thing I've realized about businesses in Ghana is that when the owner dies, the business dies with the person. But in the US and other countries, you realize that, sorry, 50 years, 60 years, 100 years, the company is still existing. And the question I ask myself is, why are they doing right that we are not? It's obvious. They think about 100 years before they even begin. So before you begin that business, look at all these variables. Look at all these agreements and get the expertise to help you out with it. So we've ended tonight's program, and I want to urge you to watch us next week. Next week we are going to have Doing Business in Ghana, Intellectual Property, Trademark and Data Protection. So you've started a business. Now you have information that is peculiar to you, that helps with your work. But you're afraid someone will steal that intellectual property. How do you protect it? How do you ensure that your work is protected, that if it's out there, no one can just pick it and also use it? How do we protect you? We'll be doing that next week. So until next week, please stay safe. And as I always say, God take care of us.
Amen.
Amen. Thank you. Bye.